Welcome to the channel. Today we will be looking at Form I-601.
Before we begin, please like and subscribe to our channel for more future updates.
Form I-601.
If you have been determined to be ineligible to enter the United States as an immigrant or to adjust status in the United States, and some other visa categories, you may utilize Form I-601 to request a waiver. For information on which grounds of admissibility can be waived for your visa category, make sure to review the instructions for Form I-601. For candidates who entered the country illegally and have immediate U.S. residents or family members with green cards, like parents or a spouse, the Form I-601A is used. You must leave the country and apply at a U.S. embassy or consulate if you want to apply for a green card. If U.S. Citizenship and Immigration Services approves Form I-601A, a waiver that must be submitted while in the country, you will be permitted to attend a green card appointment there. However, it comes with qualifying requirements that will be covered later and must be applied for before you leave the United States. The I-601 and I-601A waiver application process is famously difficult, largely because of the intense scrutiny that an immigration officer applies to these applications. The procedure is highly intrusive, emotionally taxing, and time-consuming.
The procedure often takes 12 months or longer. This period of time does not account for potential delays brought on by requests for further information or by the National Visa Center, which processes hundreds of applications each day. It happens frequently that the NVC loses or ignores crucial documents. Applicants are strongly recommended to scan and make copies of any correspondence sent to USCIS and the NVC. The I-601 application cannot be used to request a waiver for accrual of unlawful presence that occurred over a period of less than 1 year during a single stay or over a period of more than 1 year during a single stay. Instead, you must make use of Form I-601A, application for provisional waiver of illegal presence. You can submit the I-601 application for waiver of grounds of inadmissibility under INA Section 212A9B if you're looking for a waiver owing to a 3-year or 10-year bar based on your illegal presence. You must have at least one qualifying relative through whom you are submitting your claim for the waiver in order to be eligible for the I-601 waiver. Applicants with K visas are exempt from this requirement. The K visa applicant just needs to show that the petitioner is an American citizen in place of a qualifying relative. For all other candidates, eligible relations may include a spouse, parent, or kid who is a U.S. citizen or a lawful permanent resident. Establishing that your eligible relatives would experience severe hardship if you were denied entry to the U.S. is essential to the success of an I-601 waiver application. Both the qualified relative and the applicant must submit a thorough declaration outlining the severe hardship and negative effects that the alien's absence would cause for the qualifying relative. Where possible, the applicant must offer written proof to support the assertions made in the declarations. Evidence should be presented to support a stronger argument. For instance, if the qualifying relative has a medical condition, is disabled, depends on the alien in a significant way, financially, emotionally, or parentally, or if there are important duties that cannot be carried out without the alien. The declaration should also list the various justifications for why the application should be granted, as well as any beneficial circumstances that might influence a DOS officer's judgment. In addition to providing the required papers where appropriate, applicants should disclose any criminal convictions, medical issues, immigration infractions, etc. Court-certified records of convictions or criminal histories are required. For health-related grounds of inadmissibility, medical records should be made available. For some grounds of inadmissibility, further supporting documentation must be provided. For instance, those requesting a waiver in conjunction with the request for temporary protected status must show that their request is in the public interest or is made for humanitarian reasons to maintain family unity. A connection between the battery or excessive cruelty that served as the basis for the VAWA claim and the self-expulsion petitioners from the country is required for a VAWA applicant to be found inadmissible under INA Section 212A9C. USCIS often considers 1. The health of the qualifying relative, particularly with regard to ongoing or specialized treatment for a physical or mental condition, the accessibility and standard of care of such treatment abroad, the length of treatment, the qualifying relative's ability to take care of themselves, and criminal history. 2. Financial difficulty, particularly as it relates to a drop in the qualified relatives and his or her children's level of living, protection abroad, financial losses, or the price of caring for sick, aged, or special needs kids. 3. Missing out on the chance to acquire a top-notch education. 4. The possibility of the eligible relative finding comparable employment abroad. 5. The applicant's background in immigration. 6. Family links to the United States, especially in light of child ages and family separation. 7. Virtuous conduct. 8. Genuine hardships, the severity of the sufferings, and supporting documentation. 9. When examining a waiver request, the amount of time the applicant has resided in the United States, whether legally or illegally. I-601A application for provisional unlawful presence waiver. In order to request a waiver of unlawful presence on behalf of an alien family based on grounds of inadmissibility under Section 212(a)(9)(b) of the Immigration and Nationality Act, qualifying immediate relatives, including a United States citizen spouse or parent, must submit Form I-601A. The undocumented person must meet the following requirements in order to qualify. A. They must be the beneficiary of an approved Form I-130 petition for alien relative or Form I-360 petition for American, widower, or special immigrant. B. They must be at least 17 years old at the time of filing. C. They must be physically present in the United States. And D. They must have accrued unlawful presence for a period of 180 days or more but less, INA Section 212A9BI2. The I-601A application cannot be submitted along with any other applications. If you do, USCIS will reject your waiver application. The applicant must speak with the Executive Office for Immigration Review, EOIR, to request a dismissal or termination of any removal proceedings after the I-601A provisional waiver is authorized. The applicant must then leave the country in order to appear for their interview for an immigrant visa at a U.S. consulate overseas. A failure to do so will invalidate an I-601A. If you are not qualified for the I-601A provisional waiver. Qualifying grounds of inadmissibility for I-601 application. The following grounds are required by INA Section 212 for aliens who have been found inadmissible during their consular interview abroad for an immigrant visa classification, the K or V non-immigrant visa classifications, or aliens found inadmissible for adjustment of status to lawful permanent residence. You can apply for a waiver of inadmissibility if you have been convicted of prostitution, an illegal commercialized vice, serious criminal activity involving immunity from prosecution, a controlled substance violation in any nation or U.S. state involving a single offense of simple possession of 30 grams or less of marijuana, or 2 or more convictions other than political ones where the sentence or confinement was 5 years or more. You can demonstrate that you have made amends and that your admission to the United States would not jeopardize the country's welfare, safety, or security if at least 15 years have passed since the behavior or event that rendered you inadmissible. If you have been found guilty of a violent or hazardous crime that does not call for an extraordinary situation that might allow a good outcome, you might not be eligible. An individual is unable to receive the I-601 waiver if they have convictions for murder, torture, attempted murder, or conspiracy to commit murder or torture. That's end for today's video. What do you recommend us to make video on? Let us know in the comments below. And make sure to like and subscribe to our channel for more future updates.